Hello, I'm Dominic Walker, JMW's Inside Man, and I'm with Rachel Airriess. Rachel is a paralegal in JMW's Commercial Litigation Department, and Rachel specialises in property litigation. Hello, Rachel.
Hi, Dominic.
Hi. So there's been a recent decision in relation to nuisance. I don't know if you want to just give us an idea of what's happened and maybe a bit of an outline of what nuisance is.
Yeah, so just to give a bit of background to anyone who may not be aware of what nuisance is, it is a cause of action where one party can enforce on another party where there has been an unreasonable interference with the enjoyment of land. And in this particular case, it referred to noise nuisance. So in this case, since 1951, Mona Airfield has been used by the Royal Air Force as a relief landing ground for the nearby base at RAF Valley in Anglesby, and also as a runway where trainee pilots undertake drills. In 2003, the claimants, Mr. and Mrs. Jones, purchased land about a mile away from the Mona Airfield and began to develop the land to create a holiday and leisure park. Before this, it had actually been used as farmland. They were also complaining that the officers were flying noisy planes over deliberately to intimidate them. The judge dismissed the nuisance claim as evidence had indicated that the noise of the aircrafts, which had gone back such a long time, was an established pattern of use that failed to be considered as part of the locality.
And so, I mean, we're talking about noisy neighbours in a commercial sense here, but are noisy neighbours then going to amount to nuisance?
So as the judgment in this case really demonstrates, the nature of the locality and whether a particular activity will constitute nuisance will often depend on where the nuisance is carried out, so the location of the nuisance. By way of an example, if you buy a house in 2001, and then a factory is built in 2003, which is really noisy and disruptive, then you could have a claim for nuisance because you had lived there before the factory had been built. However, if it was the other way around and you moved into that house long after the factory had been built, you will unlikely have a claim for nuisance, which is demonstrated in this case.
And what's your general advice, Rachel, for anybody who's sort of experiencing nuisance or noisy neighbours?
So if you believe that your neighbour is causing you disruption, then the first thing that you should really do is take a step back and really assess the situation. Is the behaviour as bad as you really think it is? Is it as disruptive as you really think it is? And if it is, if you believe it to be, then what you should do is you should approach your neighbour and explain that this is causing an interference to your enjoyment of your land, and see if they're willing, to come to an agreement with you. If you still think you cannot resolve the situation, then please do get in touch with our property litigation department and we'll be more than happy to assist.
Thank you very much for your insight, Rachel. And of course, if you'd like to contact Rachel, you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.